8:40 a.m. Attorney Matt Hauser for the plaintiff. The defendant is here from Calhoun County Jail.
Okay. Good morning to everyone.
Good morning, Adam.
Mr. McKediak, I'm going to ask you, are you contesting or disputing anything in this case?
Yes, I am. The only thing I'm disputing is the custody.
Okay.
This is cool. I'm totally fine with that.
Okay. Well, what's going to happen if you're going to contest it? You're going to have to do something. You're going to have to file in this case, you've been defaulted. You'll have to file a motion to set aside the default. You'll have to file then, at that point, if the court's going to do it, then you're going to have to file an answer and you're going to have to proceed in that manner. So it's up to you on what you do. But what I'll do is I'll take some proofs today. I'm not going to enter the judgment. I'll give you a week to get everything done and filed if you want to contest it. Okay?
Yes, sir.
Okay. Ms. McKediak, we're going to take some testimony from you. So if you'd raise your right hand, we'll have you sworn in and then take some testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, Your Honor.
Go ahead, Mr. Hauser.
Yes, thank you. Good morning, Miss McKediak, and how are you doing today, ma'am?
I'm good.
Good. I guess it's been stated just for completeness. Could you please identify yourself and spell your last name for the record?
Yeah, my name is Summer Nicole McKediak. It's M-E-K-E, D as in David, I-A-K.
All right. Thank you. And at the time of the filing of the complaint back on December 6th of 2023, had you been a resident of Calhoun County for 10 days?
Yeah.
And had you been a resident of the state of Michigan for 180 consecutive days?
Yeah.
Were the allegations in the complaint for divorce true at the time the complaint was filed?
Yes.
And do those allegations remain true today?
Yes.
Okay. So in the complaint for divorce, there's been allegations made that the marital relationship, to the extent that the objectives of matrimony have been destroyed and there's no reasonable likelihood that the marriage can be repaired. Is that correct?
Yes, that's correct.
All right. So if Judge, just to be clear, so if Judge Kirkham today did not grant the judgment for divorce either today or at the expiration of those 7 days, are there any circumstances in which the two of you could live together as a married couple?
No.
And I guess just so we're clear, is there any possibility of any type of reconciliation at this point?
No, absolutely not.
Okay. To your knowledge, are you or your spouse pregnant?
No.
Okay. And then can you identify the names of all the minor children born during this marriage?
Yeah.
All right. And have you had an opportunity to review the judgment of divorce and all the support provisions?
Yes.
Yeah. And you waive any claim to any type of spousal support?
Yes.
Okay. Are you satisfied with the efforts of your attorney in this case?
Absolutely, yes.
Do you have any questions for myself or for the court?
No, I don't want to drag this out anymore. I would like to be divorced.
All right, thank you. And then does the court have any questions of Ms. McKediak?
No, I don't.
All
The
right.
court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending any objection or other action being filed by Mr. McKediak within the next week. So if he files something, we will take that up at the time that he gets it filed. You'll have to notice that for a hearing, Mr. McKediak, and you have to give the other side at least 9 days notice. So you'd have to get that filed by the end of the week, actually, unless you could have her personally served if it was by next Monday, but otherwise you have to have it done by Friday. Okay? That's
Yes,
all
sir.
we'll do today. You're free to go. Have a good day.
Thank
One
you.
quick point to that, Your Honor. I guess just as the custody and support provisions in the judgment of divorce are exactly the same as the DS case,
Okay,
Aren't those already the current order of the court?
that's an order in that case. It's not in this case, so he has a right to object.
Okay, all right.
Objection.
Thank you.
Thank you.
All right. Let's go, let's continue on to our third one here. This is another motion for entry. We've already
Jennifer,
taken
can you
the
hear
proofs
me?
in this one.
I can hear you now. Can you hear me? Yes. We cannot see you, but we can hear you. Calling case.
Court will note the appearance of Ms. Reed on behalf of plaintiff, Ms. Roberts on behalf of the defendant in place of Attorney Kelly. This matter is before the court on the defendant's motion to compel discovery and for enforcement. In this matter, I've read all the pleadings, so I don't need you to simply reiterate those. Ms. Roberts, you can proceed.
Well, Your Honor, like, as you just said, I guess I'm not going to restate everything that was already pled in our motion. I guess I would just simply state that, you know, I understand that 2.301B4 says the serving party should initiate discovery by a time that provides for a response before the discovery completion date. Our request was in early November. However, you know, there was ample time to respond or otherwise request more time from the court to be able to respond than waiting 3 weeks to simply state, now it's past the time. I'm not gonna respond. I guess that specifically in regard to the issue with that discovery.
Okay, thank you. Ms. Reed, anything else other than in your pleadings?
Just in our pleadings, Your Honor, the discovery rules are in a place for a reason. The discovery rules will not follow in this matter, which is why we filed a timely objection to them, stating that, again, they were not timely, so that's why we're objecting. And then regarding the payments on the mortgage, my client can afford to make her half of the payments as Mr. Brad is not paying child support. So we're asking for attorney's fees as we believe this motion is frivolous as defendant and defendant's attorney did not follow the court orders or the rules.
Okay. Ms. Roberts, you acknowledge that they stated that your client's in arrears $3,182.
So in regard to the bills, not paying ordered bills,
Wasn't my question. The question, do you acknowledge that he's in arrears $182?
well, personally, because I'm standing in for Attorney Michael Kelly today, I'm not specifically aware of the arrearages.
Okay. Okay. Well, what the court's going to do is obviously we note on the discovery, court will note that the defendant didn't again file the request for discovery within sufficient time to allow the plaintiffs to complete the discovery. Notwithstanding that the court is going to allow the extension and would order that the discovery would be due 7 days prior to mediation. The court would order that the plaintiff would pay the mortgage, taxes, insurance for the 4 months that were missed forthwith, less the amount of $3,182 owed in child support by the defendant or such other amount. So if the amount turns out to, let's say, because of the way it's calculated that he had a payment that was in, but again, it's not the $3,182, that would be reduced by any payments in the meantime, because I don't want obviously to put a set amount on if that's the incorrect amount. So it would be the $3,182 or what is owed, what the arrearage is owed at the current time. And the court would order that, again, that the plaintiff would pay the difference in that amount forthwith. The court will order that the defendant then is given a credit for the amount that either the $3,182 or such other amount is owed when he has paid the mortgage company for that particular amount. So, sir, you're going to have to do that and pay them forthwith as well to get that taken care of. And the court will not award any attorney fees at this time. Again, subject to later determination as the parties comply with the current order. And I'll ask Ms. Roberts that you would have her office prepare the order to that extent.
Okay,
Another under 7-day notice of entry.
thank you, Your Honor.
Thank you. You're free to go. Have a great day and a great holiday. Court will note the
Thank
attorney
you
of
as well. Thank
the attendance and the appearance of Mr. Bank on behalf of the plaintiff, Mr. Toth, and yes, one is obviously shadowing him, Ms. Goodson. Welcome. In this matter, we have Attorney Polderman on behalf of the receiver in this matter. This matter is before the court on the Mr. Toth's motion to uphold the charging lien in this matter. So why don't I go with the Mr. Bank? Do you have any problem with Mr. Toth's charging lien in this case?
I have no problem with him getting paid. I have no problem with having a charging lien against Mr. Wickstrom's share of whatever monies Mr. Polderman may be holding. As long as it doesn't impact my client's share of those monies. And I have no problem with the distribution as long as it doesn't impair Mr. Polderman's obligations to pay certain debts, particularly tax debts, pursuant to the settlement agreement. But if it comes out of Mr. Wickstrom's share, by all means, Mr. Toth should get paid.
Okay. Mr. Polderman, do you have any, I guess, dispute with that as outlined by Mr. Bank?
I do not, Your Honor. I agree with Mr. Bank's position. I've had a chance to speak with Mr. Toth as well and explain to him the receivership estate does have funds that I'm holding in trust, but we're working through a number of tax issues with the IRS. We've been at that for some time. I don't know when it will be resolved, but at this point in time, Mr. Wickstrom does have obligations to the IRS, and until those are resolved, I can't disperse to other creditors of Mr. Wickstrom. But I have no objection to the relief that's being requested today, which is a recognition of the charging lien on any funds due Mr. Wickstrom.
Okay. Mr. Toth, does that, again, take care of your issue? It's like Mr. Toth is frozen up on us.
It does, Your Honor, yes.
Okay. Mr. Toth, why don't you then go ahead. I'm going to say, why don't you go ahead and do an order consistent with that resolution and submit it under 7-day.
Thank you, Your Honor.
Very good.
Okay.
Thank you.
Thank you. Thank you, everybody.
Good
You're
to
free
see
to go.
everyone.
Have a good day and a good holiday. Court will
Same
note
to
the
you.
appearance of Ms. McNiff on behalf of the plaintiff, defendant appearing in pro per. This matter is before the court on the plaintiff's objection to the referee recommendation and order of November 12, 2024. Ms. McNiff, I've obviously read all the pleadings. I don't need you to reiterate that. Is there anything else you'd like to say?
No, Your Honor, just that we think that this matter should be resent to the referee for a full hearing on the issues.
Okay, thank you. Mr. Williams, what's your response?
My response is, I was happy with the referee's judgment. I don't feel like there should be any change in parenting time. I feel like my daughter has a really good bond with me, and to rip that away from her would be pretty hard for her.
Okay, well, I don't think they're trying to, at least based on the pleadings, I don't think they're trying to do that. But what happens, the court will note that the pleadings state that the defendants failed to participate in medical decisions, failed to take all of his parenting time in this matter. Court notes also that the pleadings state that the defendant is back to work full-time, that the report was calculated on a lesser amount. So in view of that, what the court will do is the court will refer the matter back to the referee for a determination on legal custody and child support. And you'll be notified by the referee as to when that hearing will be held. And you're free to go today and have a wonderful day and a great Christmas.
Thank you, Your Honor. Your Honor, we also had the issue with the child's bedroom in the violation of the judgment regarding the child needing to have her own bed in her own bedroom. Will that also be referred to the referee?
Yes, yeah.
Okay, thank you.
Okay, thank you.
All right, thank you.
Have a good day.
Thanks to you.
Am I hanging in here?
Yes, you're hanging in.
We missed
Court
you.
will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion to require plaintiff to comply with the judgment of divorce. Obviously, I've read the pleadings in this matter, Ms. Thomas. You don't have to reiterate those. Do you have anything in response to Ms. McNiff's answer?
Well, there's a lot of things to respond to because there was a lot of inaccuracies in there.
Well, let's respond to the salient points. There was a lot of ancillary and I believe superfluous stuff included, and I don't need you to respond to that.
Okay. All right. So the issue is, of course, whether or not and when Ms. Gentry, Ms. Tinsman has to respond or has to remove his name from the obligation. The concern is that now we've learned that her intent is to not do so for another 18 months. The problem, or to even list the house for sale for another 18 months, which would even be beyond that. But the problem of it is that it's affecting Mr. Gentry's credit. It's affecting his ability to do other things at his house and ownership of his house. And so it was supposed to be to hold him harmless. And in the response, there's several things that aren't true, including, who had the affair. I mean, there's all kinds of things. But again, as you indicated, they're ancillary things. The bottom line of it is this case was one where Ms. Tinsman's attorney drew up the document. Mr. Gentry was not represented. It was after he had met with both of the parties, and they both were of the understanding at that point that she was going to refinance and get this taken care of right away. It's now more than 2 years later, and nothing's been done. And it seems that Ms. Tinsman is of the belief that she can do this if and when she wants to. And it is affecting his credit. It is affecting, there's all kinds of excuses, but every excuse is one that frankly is under Ms. Tinsman's control. We just are asking for a date by when it needs to be done, because one wasn't put in the initial judgment of divorce that was prepared by Ms. Tinsman's attorney. And again, the amount of things in the response were a little flabbergasting for us, quite frankly, but there are 5 missed payments according to the document from the credit union. And so we're just simply asking that there be a timeline put on this matter.
Okay, thank you. Ms. McNiff, you talk about all sorts of things in the response. What's the date that she'll have this refinanced by?
Your Honor, as we responded in detail, the problem she's going to have is the financing companies want her to have 2 years of either W-2 or 1099 wages. And she simply doesn't have that. And so she won't be able to refinance until then. She certainly wants to sell the house sooner than 18 months. But we need a resolution of the parenting time issue. I have to file a motion, I think, to resolve that and to get that to a hearing.
Okay,
but
that's not before me today.
No, I'm just, and I understand that. She has an intent to sell.
Give me a date.
I don't have a date, Your Honor. I don't. But the big thing here, Judge, is a judgment of divorce for the property provisions is really a contract. And it's not for the court to reform the party's contract. It should have been on Mr. Gentry to ask for a date when he wanted his name off of that property. And without that being in the judgment, there is no date. I think that Mrs. Tinsman will do it, but the judgment speaks for itself.
Okay. Well, in this matter, it's been approximately the judgment was back in on February 13th, 2023. So we're going on close to a year. Obviously, that's sufficient time to get the matter resolved, and the court's not going to wait indefinitely for the plaintiff to qualify or whatever. And because we can't be given a date, the court is going to order that the house be sold, listed for sale forthwith, and be sold. If something happens in the meantime, she's able to refinance, the court would consider that. But at this point, if there's no date, that she's going to have to list it for sale and have it sold forthwith, and provide Ms. Thomas with the listing agreement. I will require that that be done within 14 days of today's date.
Judge, could she have a little bit more time just
Nope.
due to the holidays? It's going to be
She's had
difficult.
sufficient time. She can do it within 14 days. Thank you.
Thank you, Judge.
You got it. You can submit that, Ms. Thomas, under a 7-day.
Will do. Thank you.
Thank you. Have a good day and a good holiday.
Thank you.
Thanks, you too.
24 at 9:59 a.m.
Good morning to everyone. Court will note the appearance of Ms. Oatman on behalf of the plaintiff, and I've been advised that Mr. Conkle is going to have an attorney, Mr. Jamesman, but he's not here presently. But we do have an agreement. Is that correct, Ms. Oatman?
Yes, that is my understanding, Your Honor.
Okay, why don't you recite what that is, and I'll see if Mr. Conkle can affirm that.
For sure. All right, so my understanding is that the parties agreed to joint temporary legal custody and joint temporary physical custody. The parenting time will be with father on Sundays at noon until Wednesdays at 7 p.m. And then the other time will be mom. The holidays will be per the policy unless they agree otherwise. And as far as child support goes, we need to exchange updated income information so that the attorneys can draft an appropriate child support order according to the Michigan Child Support Guidelines.
Okay.
That is my understanding.
Thank you. Mr. Conkle, is that your understanding of the agreement?
Yes, from what I understand.
Okay. And you going to have an attorney, but the attorney's not present now. You agree to go ahead without the attorney on today's hearing?
Yeah, if we're gonna redo the child support and I get my boys from Sunday to Wednesday, I'm happy with that.
Okay. Okay. Well, we'll let Ms. Oatman draft those particular orders and send them out to your attorney, and then you can address anything at that point if we need to. So at least today you're free to go. Have a good day and a wonderful Christmas.
Thank you, Your Honor. 10:02 a.m.
Court will note the appearance of Mr. Snyder on behalf of the defendant. We have competing motions. The defendant and plaintiff have both filed motions to amend the final consent order regarding custody, parenting time, and support in this particular case. Mr. Snyder, why don't you proceed first?
Judge, yes, I spoke to your office a little bit ago. I'm actually at home sick this morning. I'm not in my office. I spoke to my client. I spoke to Mr. Luke asking for a continuance. He denied that. So I'm asking you for a continuance because I don't have my motions in front of me. And I'm at a little bit of a disadvantage being sick at home this morning.
Okay. Mr. Luke, I understand you were present last week and Mr. Snyder was not, and we put it over a week. Obviously,
Your Honor, when we had our hearing on the 9th, we put it over for 2 weeks until today. There was no hearing scheduled last week.
well, unfortunately we did have one scheduled last week, so or at least
I was
came up on the schedule.
Yeah, I was not informed of that. When we met on the 9th, we put it over for 2 weeks, and there was nothing sent to me with any hearing scheduled for last week, Your Honor.
Okay.
Your Honor,
Mr. Luke,
he is
what's your
lying.
position?
He is
Okay.
making false statements to the court. I sent it through the mail to him, and I also emailed him. I sent him the email on December 5th at 4:07 p.m., and I also sent it to the mail to him on December 5th. I have tracking number through the mail as well.
Okay. Well, why don't we do this? As I hate to put this matter over again, but obviously, if the court finds there's a basis for either motion, then we're going to have to refer them, and we're going to have a hearing anyway. But I don't want to make Mr. Snyder appear in this matter if he's not feeling well, if he's ill. So the court will put the matter over again for another week, and we'll be back next week at the same time to address the motions. Okay, Court will note that this matter is before the court on the plaintiff's objection to the referee order. Ms. Gilman, what's obviously a lot of times people will not agree with the referee, but that's not a basis for the objection. You have to establish that the referee made a factual or legal error in the determination. So what is the factual or legal error that the referee made?
That I was to pay child support to Mr. Hanker and the minor child. I have sole legal and physical custody of the minor child, and Mr. Hanker and his guardian have yet to submit his income.
Okay. Well, again, you've stated what happens, but what is the error that the referee made?
That I'm to pay child support.
Okay, I don't have the order in front of me right now, but so you were granted legal and physical custody?
Yes, sir.
Well, I don't understand the issue on the child support. Maybe Mr. Hanker, maybe you could enlighten me if there's what's happening or whatever.
Last time, Your Honor, we had trouble getting into the Zoom meeting. So me and Jeffrey were currently not able to hold the hearing. So you guys did not have on record Jeffrey's income, what he brings in a month to do child support. So when you guys did the calculations, it showed him as 0 for the income, and it showed Samantha paying Jeffrey for child support.
Okay. Well, clearly, if she has custody, then that would not be appropriate. What we'll do is we'll refer the matter back to the referee on the issue of child support and get this matter hopefully resolved at that time.
Okay.
Okay. Okay. Thank you. They'll be in touch with you probably about a week or so.
Okay.
Thank you, Your Honor.
Have a good day and a nice holiday.
You too. Thank you.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's objection to the referee determination. Mr. Turner, in your objection, you say incorrect information. That doesn't tell the court anything, so I have no idea what you're objecting to.
Okay, it was an error made stating that I didn't have insurance, but I stated that I did, so I sent proof of insurance.
Okay, so that's the only issue is the insurance issue?
Yes, and I wanted to ask, can I get my son's social so I can add him to my plan? I asked the mother, but Ms. Lynch won't give it to me.
Okay. Well, let's have some input from Mr. Magnuson. Mr. Magnuson, what's your response?
I can indicate, and I believe Mr. Turner knows this, and the best of my information is that this matter is set for a further hearing in front of the referee on January 22nd. A lot of times at these hearings, we don't get all of the information. Sometimes parents don't have their insurance information with them for the exact amounts and things like that, and there are issues regarding custody and parenting time. So what the referee did in this case was essentially enter our order and then set it for a further hearing down the road, which I believe is in January, and the party should have a notice of that.
Okay. Did you get notice of that, Mr. Turner?
Yes, I got the notice for the custody, parenting time, and the final.
And the support issue as well?
Yes, sir.
Well, what happens is, as Mr. Magnuson points out, you'll have an opportunity to bring all of that information on the insurance and everything else with you as far as the amounts, what your premium is, that the child is covered, et cetera, and or can be covered, and then appear at that hearing on the 22nd. And the referee will take all that and then basically do a final order at that time.
Okay.
Okay. Anything else, Mr. Turner?
No, sir. That'll be all.
Mr. Magnuson?
No, thank you, Your Honor.
Okay. Thank you. You're free to go. Have a good day and
Richards,
a night.
The defendant, the respondent is not here.
Okay. Ms. Richards, I note you had filed this petition for a personal protective order. Originally filed it before Judge Yost Johnson, then she recused herself and sent the matter to us, but we note in looking at the file, you've not yet accomplished service on the respondent, and you've stated to staff at least that you want to proceed and attempt to file a motion for alternate service. Is that correct?
Yeah, and I did do that and just emailed it over to the PPO coordinator. So that was my mistake of not getting it done sooner.
Okay. Well, what we're going to do is we'll look at the motion for alternate service when it comes in. If we grant that alternate service, then you're going to have to accomplish the alternate service based on whatever the court determines is appropriate, and then you'll have to schedule the motion again at that time. I'm going to give you 30 days to accomplish that. It sounds like you've already got the motion, but if we grant the motion, then you'd have to do that and get the matter rescheduled within 30 days because we need to get this matter resolved.
Okay.
Okay.
And she put the dates and times that she attempted service and how long she did the surveillance after attempted service as well.
Okay. Well, good. That helps. That gives the court more information. So
thank you.
That's what we'll do, and then we'll see you back at some point next month then.
Okay. Thank you.
Thank you.
Yeah.
You have a good
Attorney
day.
Bolden for the defendant, sorry.
Good afternoon to everyone.
Good afternoon.
Ms. Davis, I'm going to start with you because you are the plaintiff, and just checking, what do you believe to be the disputes in your case?
I believe we're just trying to find a good schedule for our son, which I'm pretty sure that we have come up with one.
Okay, I'll go to Ms. Bowen. Ms. Bowen, is that your understanding that the parties have been working to get it resolved, and it looks like they may have it resolved?
Yes, Your Honor, we did submit, the party signed a judgment of custody and UCSO with deviation on the 17th, which we have submitted to the court. You might not have received it yet to be in front of you, though.
Okay. Well, I haven't seen it yet, but I'm sure it's working its way up. So what I'll do is if you do have resolution, we can dispense with the scheduling conference because there's no need for that if you've come to a resolution. So we'll just await that. I'll probably set it for maybe about 30 days out just to make sure we get the paperwork and the approvals and all of that. If we do get it before that time, then we'll proceed to get it concluded. But if not, then we'll find out what's the, I guess, any difficulties that we might have at that time. So anything else, Ms. Davis, any questions, things of that nature?
No, Your Honor, I think that's it.
Okay, Ms. Boland?
None, Your Honor, thank
Okay,
you.
well, we'll let you go and not keep you any longer then. So you're free to go. Have a good day and a wonderful Christmas.
Thank you, you as well.
First, defendant number 3, Shaylin Heinzelman.
Okay. Good afternoon to both of you. This is before the court for a status conference. I'll start with Ms. Mueller-Wilson. Ms. Mueller-Wilson, I know that you just had, obviously, the last defendant served on December 5th. So tell me what's going on in the case. Where are we at?
Your Honor, exactly what you said. We were working on getting the defendant served. My understanding is that the defendants are now served. Ms. Heitzelman was served a little bit earlier, so she, of course, is appearing. The other defendants may or may not know about the, I probably don't know about today's status conference because they were just served late last week, is my understanding. So I wouldn't expect them to appear. Ms. Heitzelman has contacted our office with a defense that she's provided us documentation to substantiate her defense, which is in the hands of my client awaiting decision as to whether or not they're going to release her as a defendant.
Okay. Ms. Heitzelman, is that your understanding of what's happening at this point?
Yes, that is 100% correct.
Okay. Why don't we, because we just have the other defendants in and they haven't appeared, why don't I set this out about 30 days? We'll get a new status conference and the two of you can work together to resolve any issues you have. And then at that point, we'll get together with the other two defendants, hopefully, and be able to move the matter along.
Very good, Your Honor.
Okay, thank you.
Thank
Free
you.
to go.
Thank
Have a
you,
good
Your Honor.
day and a wonderful holiday.
You as well. Thank you, sir.
You're aware.
You too.
So there is a mediation status report now for Ferguson. It says that they settled.
Oh, okay.
But the report is indicating that the final documents will be filed on or before March 15th of 2025. So we actually had calls from Attorney Mahoney and Marcus wondering if we could, dispense with this settlement conference, but I said, with that time frame of 3 months for final orders, I was not too confident. I was hesitant. So I'm just going to we told them we will still have it. Just to, I guess, at least just have them say that to you.
Okay.
I do not have Attorney Mahoney right now. But, well, let me get in the people that I do have here.
And do it that way. What do you think?
Well, Judge, as much as I appreciate the sentiment, we are settled in this matter, and I know Brian for a long time, and even though he knew about today and emailed us a short time ago about it, it does not surprise me one bit that he is not prompt.
Okay.
In any event, I have no need for another tube of blood from him because I'm getting what I want in the settlement.
Well, that's great then. So, okay, and we know we're getting on Mr. Applebaum. You had stated you got to stay with regard to you, so you're here, but nothing that you have to add at this point.
I'm just more curious, did they agree to give the stuff back or pay money, or it's none of my business, Mary?
They're paying the money.
Okay, great. Great.
And so
I'm gonna
nothing-
zoom out, wish the Lions well, and see you next time.
Okay, thanks.
You can sign my name to a dismissal, Mary, okay?
Thanks, Alan.
All right, guys, have a good holiday.
See you the next one.
Zatuna, what your thoughts on this? Obviously, you've got resolution. Is that correct?
That is correct, Judge. And again, Mary Mahoney on behalf of the plaintiff, Ferguson Enterprises. We enlisted the aid of Judge Mullally from the west side of the state to conduct a mediation for us, and
Great.
successful in finally prying money out of the hands of the person who's got the goods and who's really been the cause of this whole litigation.
Okay.
That money is to be paid by the end of the year. There's another small piece that's being paid over time by Mr. Zaytuna's client. Our entire settlement was placed on a recorded statement with Judge Mullally, as well as confirmed later by email. So I have every confidence that we're going to be able to put together documents that reflect that settlement, and that there will be no further need for court intervention. The only possible area would be for enforcement of a valid settlement that we have on the record with Judge Mullally.
The staff mentioned that something about the final documents wouldn't be available until like March 15th. Is that correct?
No, Your Honor. I think that was some kind of a docket entry. I'm not sure where that came from, but it was never our intention to drag this out to March.
Okay. Well, I appreciate that, because I don't want to drag it out to March either.
The final payment is not due until March.
Oh, maybe that's
and so that was but given the relationship between Ferguson and Running Right, we have employed a way to sort of get around that. It would just be a pocket judgment that's being held, that the case would only be reinstated for purposes of entry of a consent judgment.
Okay. Okay.
And if that's acceptable to the court, then the documents will reflect that. I did plan to get an initial document circulated last week, but as I was telling Mr. Zaytuna earlier today, I got bit by a cat, and I ended up spending half of last week in the hospital. I went there right after our mediation and got stuck there for 3 days. So I am getting that drafted, and we'll have it sent around to the parties. You're on mute, Brian.
Yep, sorry.
Mr. Zatuna, is that your understanding of the situation?
Yes, Your Honor.
Okay, thank you. Mr. Marcus, when you didn't show, on time, I mentioned to the other attorneys that we could always assess some cost against you, and they said they weren't willing to do that. So you must have a real good relationship with the other attorneys.
I appreciate that very much. And yeah, I think if we do it by minute though, and the next time, I'd really appreciate it rather than at full assessment.
Okay. Okay. Well, they delineated what the resolution is, so the court will simply await the judgment in this matter, and let's get that circulated, get signatures, and get it to the court, and we can get the matter off our docket then. And I appreciate all your hard work and what you've done to get this resolved.
Your Honor, my office did file a couple of motions last week, or at least one motion, a motion for leave to file another motion for summary. Obviously, the need for that is obviated by this settlement.
Okay.
We'll will simply withdraw. Yeah.
Okay. Anything else from anybody else?
No, sir.
Okay.
We
Well, thank
appreciate
you.
all the time you spent with us, Judge. This is it's been a pleasure with you as always, and I'll get those documents into you as quickly as we can.
You're free to go, and have a Merry Christmas.
Thank you.